Ladies and gentlemen, welcome to our next focus, which is the fine line between judicial overreach and executive inaction. With our focus particularly on the judiciary, I'm joined by Justice Ashok Ganguly of the Supreme Court, formerly of the Supreme Court, Dr. Abhishek Manu Singhvi, the country's leading constitutional lawyer and Congress MP, and Devajit Saikia, who's Advocate General of the Government of Assam. Thank you all very much for joining me. I'm going to start with the most contentious issue at the moment, which is the manner in which the judges have been making observations, especially in the Nupur Sharma case. Why don't you take it up, Dr. Singhvi, since you are at the moment in the heat of all that happens in the Supreme Court? Did the judges exceed their jurisdiction by making observations in the Nupur Sharma case of a kind that, according to critics of the judiciary, have virtually put her in the line of fire?
Let me make it pointed and short. The answer is no, Rajdeep. I see it a little differently than what you have been seen commenting on this issue. Whenever a litigant initiates an action in the Supreme Court, he takes a concomitant risk. The risk is that he's invoking the jurisdiction of the court, as Nupur Sharma was, for some relief. The risk he or she takes is that the court, while dealing with the matter in the course of questioning, eliciting the truth, giving their views, there is an interactive participatory process. Nobody, least of all the judges, claim it to be binding. Nobody, least of all the judges, say that what we are saying is a judgment. But you cannot, once you are the one who has invoked their jurisdiction, prevent them from participating and dealing with you and saying, look, and in Nupur Sharma's case, people forget this, we are dismissing your plea, which is based on the Arnab Goswami judgment, because we think that the Arnab Goswami judgment does not apply to you. For the following reasons, A, B, C, D. You set the country afire, you said this, etc. Now, this is a perfectly legitimate interactive process, and I think it is being distorted by suggesting that the court was at all intending to make binding observations. It doesn't bind any future thing. It doesn't affect Nupur Sharma's rights in a legal sense. Lastly, equally wrong is to then lampoon these judges, to stigmatize them, to attack them, to deal with them in social media, as partly in an academic sense Justice Pardiwala said in his lecture, because this is misunderstanding the process when you are arguing a matter. If you have such delicate toes and delicate fingers, then don't go to the Supreme Court.
So are you saying, therefore, it is not judicial overreach according to you? She and her loose tongue have set the entire country on fire. She has threat, or has she become a security threat the way she has ignited emotions across the country? Are these observations that do not constitute, according to you,
no, because they are
overreach?
saying that we are making these observations to dismiss your request. A request was to transfer all the matters on the basis of the Arnab Goswami judgment. So what the court is saying is that according to us, the Arnab Goswami judgment does not apply because we believe that you are disentitled to relief because you made inflammatory comments.
So you're saying explanations of a judgment should not qualify as judicial overreach. You agree with that, Justice Ganguly? Do you believe judges should be making these observations in highly sensitive matters, or just give the judgment?
Well, before answering this, may I say one thing? These days, what is happening is most of the oral observations are reported and not the order which is passed. That is an unfortunate way of reporting things, because what is reported is something which is sensational. You see, as I agree with Manu Singhvi, that the mere oral observation is not binding on anybody, because the judges' thinking process, judges were thinking aloud. They were there before passing any order. I can say from my experience, there has to be a thinking process which is reflected in the reasoning in the order. What is there in the reasoning of the order, that will bind, and that is never reported. But possibly in this case, I do not, correct me if I am wrong, the learned lawyer, Mr. Maninder Singh, was appearing for Mr. Sharma, Mrs. Nupur Sharma. That learned lawyer withdrew the petition, it was dismissed as withdrawn. The learned lawyer never risked the situation of getting an order, adverse order. But whatever has been observed by the there is some truth in it.